Has every OLC memorandum that is cited in the OPR final report been withdrawn?
Senator Leahy, first, with reference to the executive order, the President in January of 2009 himself directed that none of the OLC opinions post 9/11 that related to interrogation techniques should be relied upon. I can confirm to you that 7 of the 8 OLC opinions referenced in the OPR report have in fact been formally withdrawn. The 8th OLC opinion is covered by the executive order, and there has not been occasion otherwise to formally withdraw it because it actually is a memorandum that refutes or modifies some of the 7 other OLC opinions. But in any event, the executive order makes clear that none of these opinions can be relied upon.
No other outstanding letters or opinions?
Not that I know of, Senator.
Now, the DOJ website now makes available to the public a number of withdrawn OLC opinions. Is that the full set?
Senator, let me communicate with OLC and get you a definitive answer on that.
And my staff will make sure to fully define that question. Has the Judiciary Committee been provided access to all OLC documents related to the Bush administration's interrogation, detention of individuals after September 11th?
Again, I'm going to have to go back and get definitive confirmation.
And if we haven't, will you tell us when we'll have it? I don't want to have to subpoena this again, but I will.
Yes, Senator.
And that includes the index of all OLC opinion. And if it helps you when you go back to ask that, assure them I will issue a subpoena for the index if I don't have it.
I know, Senator, that they are working on an index, and I will communicate with them about that also.
Thank you very much.
You're welcome.
Senator Sessions, I appreciate your courtesy in waiting.
Thank you. Mr. Grindler, I know Senator Durbin continues to repeat a party line view that post 9/11 that these unlawful combatants were to be tried in civilian court, and he takes some of these cases involve financing of terrorism and things of that nature, and adds them up in his 190 cases. I would just remind you that the President Bush created a courtroom and a procedure to try cases in Guantanamo, which Attorney General Holder has said is legal, constitutional, and not in violation of our treaties. In fact, the only reason they chose not to do it was because he thought, as a policy decision, it's better to use federal court, which I steadfastly disagree with. And so those cases were set up to be tried there. The Attorney General has issued an opinion that the presumption is that people held at Guantanamo will be tried in civilian courts and not in those courtrooms set up in Guantanamo, and that Congress acted over the last several years to pass legislation that responded to Supreme Court criticisms of trying cases in military commissions. They've refined the military commissions, as has the Department of Defense refined military commissions that now fully, I believe, comply with any treaty, constitutional, legal, or court objection. And so this is, to me, a pretty clear question. The President said explicitly he did not believe these individuals should be given Miranda warnings. He said that publicly, I think, in the 60 Minutes interview. And yet, when you try these cases in federal court, isn't it true when you arrest any prisoner, anybody, and make them a prisoner in the United States, and you desire to ask them questions, and they're in custody, that they have to be given their Miranda rights?
The policy that was referred to earlier, which is the FBI policy, does say that when you have someone in custody in the United States that you're required to give Miranda warnings. There are some exceptions, or at least one exception to that policy that I think was utilized in the case of Abdul Muttalib in Detroit, because when he initially was taken off the plane, he was questioned without being provided Miranda warnings. There is what's called a public safety exception, and in order to immediately determine whether there are other facts that need to be known to protect the safety of individuals at that point in time. Now, it is true later on he was given Miranda warnings. There are also in the United States procedures that require that individuals in this context be brought before a federal court for an arraignment within a certain period of time. And there are also rules relating to how you view interrogations that continue after 6 hours of detention. So these are all rules that have to be, where decisions have to be made sort of on a split second.
Well, I just would say to you that, yes, you can ask them, do you have a gun or anything on you? And those interrogations, most cases that I've seen can extend only a few minutes. But perhaps in this case it was so unusual, maybe you could go 50 minutes. But the net result is when you appoint them a lawyer and you tell them they have a right to remain silent, that definitely, without question in my experience, increases the likelihood that they'll quit answering questions and will clam up. And the fact that you would take them in military commission, such as a Christmas Day bomber who flew from an Al-Qaeda center with an Al-Qaeda bomb to the United States, Al-Qaeda being at war with the United States, and they clearly meet those standards of a military combatant. And just because you take them into military custody does not mean you use enhanced techniques, but you don't have to do the kind of warning of rights and give them speedy trials and the right to discovery and the right to have an attorney paid for by the government, because they're unlawful enemy combatants. And they don't have those rights any more than a German or Japanese prisoner captured on the battlefield is entitled to a lawyer, entitled to be told he doesn't have to answer questions if they're posed to him. That's just a matter that we've been arguing over for some time. I shouldn't have spent so much time on it. But it continues to me to be a serious matter. With regard to OPR, I am troubled by the leaks that came out of that, and that the whole process really has done some long-term damage to the credibility of OPR, in my opinion. Based on my staff's assessment of the recent annual reports of OPR, it seems that a primary focus of their attention is on leaks throughout the whole Department of Justice. If there's an allegation of a leak, they're the ones that investigate it, because leaks violate the discipline, order, and really the sanctity of justice in America. Mr. Grinnell, let's say that an improper leak occurred in a Justice Department matter. OPR would be the one that would investigate that. Is that correct, normally?
They would be involved in the investigation. Sometimes if there's a reason to believe that the leak may involve a criminal violation, it may be that a U.S. Attorney's Office might be brought into it, or we've had circumstances in which...
Well, I understand, and they even have a rapid response team to deal with that, which is a healthy thing.